In Alabama, under the old law, a capital murder conviction resulted in one of only two possible sentences. The only possible sentences in a normal capital murder case is life without the possibility of parole or the death penalty. Based on previous case law, juveniles could not be subjected to the death penalty. So what happened prior to the Miller decision, is that juveniles that were charged with capital offenses went to trial as a capital murder case, but life without parole was the only possible sentence that was available in the event that they were convicted of that crime. So what has happened is, once the Miller case came out, is they are still subject to being sentenced without to life. Let me strike that. What happened is, after the Miller case came out, what the court said at that point was that juvenile defendants are still eligible for life without parole. There's still possibility that they receive that, but that sentence cannot be simply handed out arbitrarily. It's not automatic, in other words, as it was prior to the Miller decision. So what happens in the legal cases a lot of times is the defense attorneys that were trying the case initially, they didn't embark on any part of what we call mitigation in a case, like you would if it's a death penalty. If you're having a death penalty case, you do a full-blown mitigation evaluation and investigation, and you try to gather witnesses and information and elicit testimony that could potentially be used to give a defendant life without parole instead of the death penalty. Because the death penalty was never on the table in a case like that involving a juvenile, that step of the process just wasn't done by the defense attorney. It wasn't, it wasn't, speaking generally, it wasn't something of, misrepresentation or not doing what was required. At that point in the law, there was no reason to embark resources to try to do that. So what has happened is, since the Miller decision came out, those cases that are eligible to be resentenced, many of the defense attorneys are going back now and doing a full-blown what they're doing is a full-blown mitigation case to make the argument that the defendant, though convicted, should be sentenced to life with the possibility of parole as opposed to life without the possibility of parole. On many of those cases, the state will still argue that life without parole is the appropriate sentence, and it'll be up to the sentencing court to determine what sentence they're going to impose. One caveat, or one thing that's a little bit different about the law as it relates to the life with parole for a juvenile convicted of a capital offense, is that if they receive that sentence of life with the possibility of parole, they still have to serve 30 years of their sentence on a day-for-day basis before they're eligible for that parole. Other life sentences don't have that same requirement.